Okay. Hello, everyone. It's about 2 after 12, and we can get started. My name is Brian Lima. I am a senior project manager with MT Consultants and also a member of the OPWA Education Committee. I will be your moderator for today's webinar. Thank you for joining us for today's webinar on a recent court decision on owners' responsibilities on construction sites, and specifically a case example involving the city of Sudbury. Before we get started, I would like to share some information on OPWA. We would like to acknowledge and thank each of our diamond, gold, and bronze annual sponsors for their generous support listed before you. OPWA is a non-for-profit organization of professional public works practitioners. We are the Ontario chapter within the Canadian Public Works Association and one of 63 chapters of the American Public Works Association. We have about 600 members who are employed by provincial governments, municipalities, consulting engineers, utility companies, contractors, and suppliers. The Ontario chapter is also set up geographically with 2 branches. In the Niagara region, we have the West Central branch, and in the Ottawa region, there is an Ottawa Valley branch. OPWA's mission statement is connecting the public works community. And that's exactly what OPWA offers its members: opportunities to connect through workshops, conferences, and social events. Another great way to connect with those in public works is to join the OPWA committee. Your creative ideas and volunteer assistance is always needed. These webinars are organized by the OPWA Education Committee. To learn more about the chapter and its upcoming events and resources available to our members, please visit our website. We have other webinars coming up as shown on the screen. These monthly webinars help to connect membership and technical and educational resources, as well as connecting with OPWA members who are experts or trained in their sector of public works. Next on our monthly webinar schedule is Highway 5353 Water Management Plant on June 5th. Webinars is one example of providing value to our membership. Coming up is National Public Works Week. During National Public Works Week, we will be having our OPWA Awards Luncheon. It'll be held at the Mississauga Grand Banquet and Event Center. Also, our popular annual OPWA Golf Day will be held. Information to be provided as it relates to those events in the near future. Here are some notes for today's webinar. Number 1, we ask that participants' microphones stay muted. They have been muted and cameras will remain off. Number 2, questions will be addressed at the conclusion of the webinar. Please place your questions in the Q&A box during the webinar. Number 3, the Q&A icon is located at the bottom edge of your screen. Click and enter your questions. And then finally, today's webinar duration will be approximately 1 hour.
Oh, well, thank you very much. Oh, sorry, go ahead.
Sorry.
Okay, well, thanks very much, Brian. So I'm Patrick Groom. I'm a partner with McMillan LLP. And I'm part of the construction group. I'm a specialist. I'm a certified specialist in labor law, but I also perform a lot of occupational health and safety, both advising on the initial front end when developing programs, and at the back end when we're actually dealing with charges before the Ontario Superior Court of Justice and the Ontario Court of Justice. So for today, Some of you may have seen some of our previous presentations about the decisions involving City of Sudbury. I'm going to be taking you through a brief summary of the case. Particularly, we're going to focus on some of the facts on the ground because that became very relevant in light of a decision that was issued at the end of the summer by the Superior Court of Justice. In that decision, it dealt with whether or not Sudbury acted with due diligence. And in fact, it found that it did and dismissed the charges. I'm also going to touch on what is a regulatory offense, just to give some context to what is a due diligence defense and what are the elements we want to be looking for. And then third, we'll be looking at key takeaways for owners, contractors, and constructors. I'm just going to make a few comments about some of the contract issues that we've been seeing so far as owners and other parties are trying to get in front of and deal with the implications of this case. So to start off, when we're looking at the facts of the charges here, the key element here is that the City of Sudbury had contracted with Interpaving to repair a water main downtown. Interpaving was the constructor and actually had control over the entire project, including health and safety program management and enforcement. Interpaving was responsible for supervising and directing the work of not just its own workers, but also the subcontractors. But the city had its own employees on the site performing quality control inspection work. Essentially, this was to ensure that the project was being done on time and that they were meeting certain milestones. The key element here, and you're going to hear me repeat a bit of this, is that the city employees themselves didn't perform any construction work, and they did not direct or supervise any of the workers who are on the site. Again, not the workers of Interpaving and not any of the subcontractor employees either. The one thing, though, that became a bit controversial is that it was the city who made arrangements for paid duty police officers to be on the site, and in particular, responsible for some traffic control management. But as you'll hear me emphasize, the Superior Court of Justice emphasized that this was done at the request of Interpaving. And throughout the entire project, Interpaving still was the party who made all decisions concerning health and safety issues. So what actually happened? Sometimes these little details get lost, but certainly they are significant. And so an Interpaving employee was reversing a grader on the project site, ended up running over a pedestrian and killing that person. That pedestrian was actually trying to cross the street, but not at the designated crosswalk area. They were actually trying to cross too close to the project site. Now, there hadn't been any fencing, and there was inadequate markings to designate where it was safe for pedestrians to move and where the construction site or site responsibility began. The key element here is that the city employees had warned Interpaving about this. They had raised this concern multiple occasions and as recently as approximately 2 to 3 days prior to the accident itself. So following the incident, the Ministry of Labor, of course, was called in to conduct an investigation. Long story short, I mean, Interpaving was charged. They had their own court case against them. They had their own defenses to deal with, etc. But with respect to the city, the ministry charged them with two key allegations. First off, failing as an employer to provide the signaler and assisting the grader, and also failing as an employer to ensure that a fence was erected around the site. There was no dispute that the city was the owner of the project and that Interpaving was the constructor. At no time did Interpaving give up that role. So the issues that were in dispute were, first off, was the city itself an employer? If yes, did the city itself breach its duties of an employer? And if yes to that question, did the city act with due diligence in trying to avoid or prevent such an incident from occurring? So in the initial decision in the Ontario Court of Justice, the city was found to be not the employer, They did not breach their duties of an employer. And even if it was an employer, then it acted with due diligence by raising these issues, for example, with interpaving. The Ontario court, though, did not really separate out the analysis of employer versus control. And so because of that intermingling, the ministry appealed to the Superior Court of Justice. The Superior Court agreed with the Ontario Court of Justice and found that the city was not an employer and did not breach its duties as an employer. However, that court did not make any mention or commentary about the what if it was an employer, and did the city act with due diligence? So just the issue of whether or not the city was an employer went to the second appeal. This was the Ontario Court of Appeal, and it was this court that found the city is an employer because it either or both, it employed workers on site, in particular its own employees who are conducting the progress or quality control checks. And two, the city had entered into a contract for the services of a worker. Essentially, because the city had entered into a contract with Interpaving, it then became an employer under the definition in the Ontario Occupational Health and Safety Act. The second element was, did the city breach its duties as an employer? So yes, the Court of Appeal found that it did, that the city failed to erect the fence. They failed to ensure that that all health and safety precautions were taken, reasonable precautions, of course, and that part of that was the fact that the city could have, for example, shut down the project. It had other options to try and force Interpaving to address these health and safety issues to the city's satisfaction, and it didn't. Now, whether or not that amounted to an exercise or lack thereof of due diligence, that issue was left. Because again, the Superior Court didn't deal with it initially. And I'm not going to comment too much about the Supreme Court of Canada decision. Simply put, there was a split decision of 4 justices on each side of whether the city was an employer or not. And consequently, the appeal is dismissed. So that means that the Court of Appeal decision that I just described still stands. Excuse me. So there is the 4th appeal now, because the Ontario Court of Appeal did not or had not been able to deal with the question of whether or not the city acted with due diligence. That was remitted back to the Ontario Court of, it was remitted back to the Superior Court of Justice to deal with or address the decision that was issued at the first trial level. Basically, in this appeal, the ministry repeated largely the same arguments that it originally put forward in the initial trial before the Ontario Court of Justice. Some of the key elements of these allegations, as you can see on the screen, that the city had permitted chaos in the intersection. That's actually a quote from their submission. They allege that the city has exercised control when its own employee, its quality control inspector, had raised the traffic management issue with Interpaving, and then Interpaving responded. Essentially, what the Crown was trying to say is that because the city had the ability to raise these issues and force Interpaving to respond in kind, that was an exercise of control. They also alleged that because the city had made the arrangements for the paid duty police officers, that was an element of control as well, even though it was done at the request of Interpaving. Another key element was that of the ministry's appeal was that the contractual authority that the city held was quite broad. They could fire workers, both of Interpaving or of any subcontractor, if their work was found to be incompetent, unfaithful, or disorderly. The city had the right to shut down the site and suspend work for any reason whatsoever. And there were other elements that essentially the city retained almost total control of the project, at least on a contractual level. However, the Superior Court said, and this was a direct quote from the decision, although in this case the city had sweeping powers, there is no evidence that those powers had ever been exercised. Excuse me. So, like, for example, the city employees were not directly involved in monitoring or directing the work of employees of Interpaving or any other subcontractor. The court specifically found that the city did not usurp the role of constructor. And in fact, the city itself was acting in response to Interpaving's health and safety decisions and how things would be set up and how they would be run on site. The court specifically found sending somebody to monitor a project does not amount to control. Again, the key elements here is that the city never used those powers that were available to it. Instead, the city, as you'll hear me say later on, stayed in its lane. The city relied on Interpaving to manage health and safety on the site. The city responded to Interpaving's requests, and Interpaving ultimately was the entity that made all decisions concerning health and safety on the project. So what now? Where does this stand? First off, as I mentioned, the Supreme Court decision is not binding. It may be persuasive, but then again, Ontario has a very unique statute. When you compare this to other provinces or even federally, for example, they actually specify in their definitions of employer that an employer only must have an element of control over the workers. In Ontario, we don't have that control element in the definition of employer. And that's why the Court of Appeal decision, which still stands, says that anybody who has an employee on site or an owner who contracts for the services of another worker or another contractor, they are considered to be employers and share in those responsibilities under the Health and Safety Act. However, when you take that next step, when you actually assess whether or not the owner, for in this case, for example, the city, exercise due diligence, that's where this control element, this control analysis takes place. So as I mentioned, there's a broad definition of employer, but we also want to just highlight that it means if you have any employees on site, not just the city or the owner in this example, not just the constructor, not just a subcontractor, but also consultants and even sole practitioners. You're still your own employee on the site. Sorry, so with that mentioned there, I'd just like to touch on what is the regulatory offense and what is due diligence and how do they interact? So when it comes to regulatory offenses, and particularly under the Health and Safety Act, the purpose is to make and promote health and safety across all parties to a project. This was done, of course, it allocates various duties among constructors, employers, and owners. A key element here, though, is that the Ministry of Labor and its enforcement mechanism can issue charges. They're considered to be regulatory offenses under the Health and Safety Act. And as you can see, the current penalties are not insignificant. A corporate employer can be fined up to $2 million. A director and officer can be 1.5 million and or 12 months imprisonment. And with supervisors and workers up to 500,000, and again, 12 months imprisonment up to 12 months, depending on the seriousness of the offense. So the key element here when we talk about a corporate defendant is that the corporate veil is often pierced whenever the ministry lays charges. Not only is it going to lay them against the company or the owners themselves, but the individual persons who act as the directing minds can also be charged. So both for a corporate or for an owner, as well as a specific individual, the due diligence defense will apply. In addition to monetary fines, just want to highlight what does the consequences of a conviction. We talked about imprisonment as well. It does mean, though, even though it's a regulatory offense, not a criminal code offense, you still have a criminal record. And there will be a public record of that offense. And in multiple situations, particularly for contractors and subcontractors, you may actually have to disclose a conviction, not just in an RFP, for example, or when bidding on other work, but if it's a personal charge, you could also have to disclose this when crossing the border to the United States, when you're selling your business, banks, insurers, etc. One thing I just want to touch on as well, while we're talking about what a regulatory offense is just to highlight an inspection versus an investigation. So an inspection, as you can see here, sometimes called an audit, is routine and the purpose is to verify compliance. However, an investigation is much like a police investigation that you might think of in common media. They are there to gather evidence relevant to the alleged offense. And this gathering of evidence can occur and usually does occur prior to laying a charge. And so with your being faced with a Ministry of Labor inspector on site, you want to make sure that you are clear. Is this an inspection or is this an investigation? If it's the latter, you want to make sure that any demands for documents, disclosure of policies, lists of employees, lists of site supers or others who are responsible for managing the site. If there's any type of request for disclosure, you want to make sure that you actually get that in writing, so that way it can be appealed later on if necessary. It really does it really can be tricky to know whether or not you're in the investigation mode or the inspection mode. In fact, it's not unusual for a Ministry of Labor inspector to actually fail to define which stream you're in. But that's why there are serious consequences that can flow, as we just mentioned. If through the course of an investigation, you end up disclosing elements that are sort of materials that may not be relevant, yet can actually lead to additional charges. So this is why, again, if there's a request for any materials or documents, you want to make sure you get that in writing. You want to make sure that you review this with counsel, and you want to make sure that the information provided is always in support of your due diligence defense, which of course, due diligence is pretty much it's the most common defense when it comes to a regulatory offense. And essentially you are trying to prove or show evidence of all the reasonable precautions, the reasonable steps you've taken to prevent the offense at issue. And only acts, policies, and other enforcement of those policies only if it's prior to the incident. After the fact, evidence is very rarely considered. So that's why we always say a due diligence defense is the only defense you can plan for in advance. Under the Occupational Health and Safety Act, there are specific limitations to the due diligence defense or its applicability, particularly under Section 23, if it's the duty of a constructor, 27, the duties of a supervisor. But with respect to the duties of an employer, which is what Sudbury has opened up for us, it's only applicable to the subsections of B, C, and D, which are respectively, letter B is to ensure all PPE is in good condition. C is to ensure health and safety measures are followed. And D, that PPE is actually being used properly. There may be other defenses, but for the purposes of this presentation, these are the key sections. And in particular, it's that Section 25C, failing to ensure health and safety measures have been followed. That's the key element of the charges against the city of Sudbury. Do want to note civil arrangements, so terms in a contract, you cannot contract out of your liabilities and obligations as an employer or as a supervisor or as a constructor if you are in fact defined as the constructor. You can talk about, like, your contracts can deal with the issues of indemnities. So that way, costs after the fact, after litigation, can be sought. But one of the key things here, and you'll hear me say this again or mentioned earlier, the city of Sudbury was found to have extremely broad powers under its contract with Interpaving. And of course, as we noted, there was no evidence that they were exercised. There's a difference between that and trying to use a contract to get out of liability for one of the definitions under the Health and Safety Act. The key element here that the court was looking at is not that these powers existed or what the contractual terms were. They were really focused on, did Sudbury actually exercise that authority or not? And so when we talk about due diligence, we want to have a program in advance because, like we said, that's the only defense you can plan for. And so I just want to talk about or touch on, what does a due diligence program entail? In particular, you want to make sure there are written health and safety policies, practices, and procedures. Depending on your level of responsibility, and I'll come back to that, you'll hear me say again, stay in your lane in a moment. But written policies, practices, and procedures are absolutely necessary. We want to make sure that we identify hazards and that any changes necessary are identified and those steps are taken to correct them. Again, one of the key elements in Sudbury was the fact that the quality control employees had raised the absence of fencing, the lack of traffic control with Interpaving as recently as 2 or 3 days prior to the incident. And the court had found that had been enough within the context of Sudbury's role and relationship with Interpaving, raising it a couple of days even in advance as the most recent time, was still found to be supportive of the Sudbury's due diligence defense. Secondly, and I think this goes without saying, if you have written policies, practices, and procedures, you want to ensure that all workers on the site have received the appropriate training and that records of them completing that training are maintained. Another element, though, it's not just educating the workers, but typically, if you're a constructor or if you're an employer who has taken on some of these roles, and I hope you weren't, you want to ensure supervisors understand exactly what their responsibilities are. That is a separate category under the Health and Safety Act, and we want to ensure that they not only understand their obligations, but that they actually carry them out. As you can see just here is a few elements of that, which includes orientation, meeting regularly with the staff, and constantly or repeatedly inspecting the site to ensure compliance with the health and safety program, responding immediately to any unsafe conditions that are raised, and also understanding the hazards that are that are present on the site. One of the key things, though, and I want to highlight this last bullet point, is that it's important, particularly, well, for all parties, but particularly supervisors, to pay attention and not fall into a routine. It's too easy to say, okay, if I do X, Y, and Z, I'm going to make sure I do that. But then it ends up becoming rote, and you're not actually turning your mind to the key health and safety issues. And so we want to bring that up. You want to educate your supervisors or other responsible persons to ensure they don't fall into that rut. So other elements of your due diligence program or defense would be monitoring and ensuring compliance. So again, there's a big difference between, for example, Interpaving having its own health and safety program versus the city of Sudbury ensuring compliance with that program. And so when the city was raising the issue about a lack of fencing and a lack of traffic control, that was part of its element of monitoring and ensuring compliance. The city itself wasn't going in and telling Interpaving, if you don't fix this, I'm going to, and then actually taking steps to do so on its own. Of course, we want to make sure we have written documentation of all steps. That would include, again, in this particular example, the emails that the city employees had sent to Interpaving that record how the problems were raised. It could also include progressive discipline, ensuring that contractors, subcontractors who need to address and correct worker behavior on site because maybe they're engaging in horseplay, they're not using PPE properly. You want to make sure that they take corrective action, and that's documented. Another element, of course, is the incident reporting system. We want to make sure those steps are followed. You don't want to have a situation where a hazard is raised verbally with somebody, or maybe a text message was sent, but then things fell off the radar and the actual issue was never addressed. Compliance with a formal reporting system is key. And of course, acting on those reports and acting on any reports of hazards or other identified problems in the workplace. As a lawyer, and you probably have heard other counsel have said this before, document, document, document. As I mentioned just a moment ago, a text message is not the greatest way to be following up or tracking a health and safety issue. What you really want to do is have not just up-to-date documentation that's in compliance with the reporting program, but you also want to make sure that, as I mentioned, you have notes of every interaction or health and safety issue. So if a supervisor is following up, for example, with a subcontractor who has to take corrective action due to a worker's behavior, you want to make sure that the sub has actually written things down, that you have a report, and that it's been put into a file to track health and safety enforcement. Here's examples of some due diligence documentation. No business, no person, nobody in this world is ever perfect, but we should be focused on and trying to document all of the elements you see here. Orientation, having people sign off, for example. Again, investigation records, corrective actions taken. Just talked about incident reports. Also audit reports. We want to make sure that if, as an owner, for example, if you're going into your GC, your constructor's office, you want to make sure you get a report from them that will say, here's our compliance. I mean, if there's incidents that are missing or poorly documented, that's where an owner would have to step in and say, no, Interpaving, you got to go and deal with this. You need to complete this investigation. You need to document this problem. What did you do? What's the corrective action? But as the owner, you don't want to actually take those actions yourself. Again, you're enforcing and ensuring that your constructor is carrying out those duties. As soon as you take those individual elements on, you're now getting into with that element of control over health and safety on a project. Just to touch on a few others, supervisor notes. We all carry a smartphone nowadays. If a supervisor is having a conversation with a worker or is directing somebody to say, don't do X because that's unsafe, it's really easy for a supervisor, a foreman, whoever's responsible for pointing that out, to actually send themselves an email. Maybe it doesn't actually rise to the level of filing a formal record. Maybe it's just an individual direction, but nothing is stopping that person from sending themselves a quick email to say, so-and-so is doing X. I told them not to do that. Describe the proper way or the safe way to do it. And the greatest thing about email isn't just that it's a very quick and convenient way to take a note. It's also got a timestamp and a date stamp on it right away. Also, in addition, it's tends to be much easier to read than handwritten notes. In particular, handwritten notes that might be in somebody's notebook, which then may get lost, or it's just very difficult to then go and retrieve that information should it be necessary. I think that I'm not going to go through too many of these, but I am conscious of the time and do want to ensure we have enough time for questions at the end. But some of the key takeaways here. As an owner, we want to ensure we're hiring a properly qualified constructor. How do you ensure that that constructor is qualified? Maybe you require core, maybe you require ISO certification. Maybe it's also advisable to come up with your own pre-qualification checklist if you don't already have one. Reason that this is important is because, as you can see here from another quote out of the Superior Court decision about due diligence, the city, Sudbury, had assessed the capacity of interpaving to perform the work safely, and ample evidence was presented to support that conclusion. Breaking that down, simply put, the city had a record of its assessment of interpaving's history. Interpaving had performed many, many, many other projects for the city in the past without any incidents and quite safely. It had the written policies. It had a health and safety program that was to be put in place for the site. And also Sudbury had the records. They had the notes to prove it. And that is a really key element. So when we're talking about building your due diligence defense, it really does start right at the outset of the project, right at the outset of even picking who is going to be the GC, who is going to be the constructor, or is there a consultant that's going to be hired to take on that role of constructor or advise, and making sure that the GC is following that advice. The key element for this role of monitoring versus implementation for owners is an acknowledgement that the owners are not the experts. You're not expected to know the elements of a health and safety program. You're not expected to actually carry out all the obligations of a constructor or exercise control over those elements. What you're there to do is ensure that there is compliance. That's the key thing. And in fact, by doing so with the city of Sudbury was able to show that it exercised due diligence and the charges were dismissed. Not to overemphasize this, but I really do have to say, if you take nothing else out of this presentation, stay in your lane. That is the most important thing. Second only to document, document, document. We want to make sure that through enforcement, you are taking actions and recording the actions you're taking. There have been many different elements that have come up ever since this decision's been issued that we've dealt with our clients. First and foremost, we want to ensure that you're reacting immediately. To be honest, I'm somewhat surprised that the court accepted the city's raising of the traffic control and fencing issue days beforehand and allowing the project to continue, particularly when, as an owner, they had the ability to shut it down for any reason. I think that the city would be in a much better position. I think right now they were lucky. They skated on thin ice with this one, but it would be strongly advisable. And I think the city would have been in a much better position if it had continued to raise the issue, if it had taken other steps, and frankly, had done something else or in addition to raising it 2 or 3 days before the incident, and then just leaving it. One of the other elements, and this is a very controversial one. In fact, we had a client in this situation where a contractor, now not necessarily one that the client had retained, it was actually a contractor retained by the landlord for their place of business. They were repaving and redoing electrical lights and whatnot in a parking lot. And the trucks that were delivering cement, that were delivering or paving the areas, were actually backing up, particularly it was the cement trucks that were backing up fairly quickly. I mean, we're not talking 50 kilometers an hour, but it was fairly quickly right through a pedestrian space where the actual designated lines, there was painted yellow lines for people to cross from the parking lot area to the entrance of our client's business. And so in that case, the client first raised the issue with the landlord to tell them, hey, you got to tell your GC you can't be doing this. And then when that corrective action wasn't taken, that owner actually, sorry, that our client called the Ministry of Labor themselves and reported an unsafe environment. The ministry sent a labor inspector and then sent an inspector. They reviewed the situation. They determined that there was no serious health and safety issue. They did ensure that the contractor changed its route for those trucks to ensure to better ensure health and safety. From that, now that sounds like a crazy idea. The fact that you're calling the Ministry of Labor onto your own site, or onto a site where you may have other responsibilities. However, if you're not getting that compliance, if you're not getting that active response from your GC, from as an owner, from your constructor, even if you don't have the contractual ability to shut down the project the way that the city of Sudbury did, this might be a consideration if it's a serious enough situation. And really, there is no better due diligence than having the ministry inspector themselves come in. And like I said, in this situation, the ministry found that the redirection that the GC was ordered to take resolved the issue. But certainly, there really is no greater due diligence than that. With contractors and constructors, I just want to emphasize is that nothing has really changed from these cases. The obligations of the constructor remain the same. The main key takeaway for a constructor or a contractor is that you should expect and you should be prepared to work more closely with your owner, or more particularly, you should be prepared to ensure you're reporting and complying and enforcing your health and safety program, and then document that and then prove that to the owner. The same thing with subcontractors. Their obligations stay the same. They are still responsible for their workers. Now, technically, while as an employer, you're responsible for the entire site. Like I said earlier, the due diligence defense is where this element of control is brought back in. There, as a sub, much like a GC, you're still responsible for the safe performance of your work. You're still responsible for ensuring compliance with the health and safety program on that site. There may be some question about whether or not you have increased exposure when ministry lays the charges for incidents that may be tangential or not necessarily directly affecting your workforce. But again, we have yet to see the ministry, let's just say, go overboard or in laying charges or conducting investigations. With consultants, the expectations, the key takeaways are much the same as an owner. You're not expected to be experts. You really do want to ensure that you've documented and that your own employees, including yourself, if you're a sole practitioner, have received site training and orientation, and that it's been documented. Like owners, you want to stay in your lane. You're not there to advise on the content or approve the content of a health and safety program. Instead, you're there to make sure it's followed, or that you and your employees follow it. And again, document. You're reporting hazards and confirming that in writing. I acknowledge, and we know that this is going to affect that delicate balance, that relationship you may have with your clients, with the contractors. But at the same time, you don't want to get labeled with or struck with charges yourselves or included in something. The last thing I just want to touch on, I am conscious of the time, but just want to make sure I touch on some of the contract implications. This is based on what we have been seeing right now with our clients. For example, an owner, in light of everything I just discussed, trying to delegate more and more health and safety responsibilities, they're sometimes it's trying to rely too much on the contract, on the constructor or on a consultant. Again, as I mentioned earlier, you cannot contract out of your obligations under the Health and Safety Act. You can only take steps to ensure that you've exercised due diligence. You can take steps to ensure you've done everything reasonable to ensure a health and safety program is followed. Part of that would also mean, as an owner, do not review. You do not want to take a constructor's health and safety program, review it page by page, and then give them all sorts of feedback. While you do want to know the key elements, want to know what you're enforcing, you do not want to be, though, seen as an active participant in developing that program, managing that program, and implementing that program directly. Again, that's the constructor's job. Another element just for contract implications, again, you want, and especially if you're a consultant, or this could be as a subcontractor, it's an acknowledgement. We're trying to include more and more of these clauses in contracts, an acknowledgement that the party is relying on the constructor's expertise. You're relying and will comply with the constructor's health and safety program. Again, you want to, as much as you want to fulfill your own duties, you also do not want to step into or usurp, to use the court's term, that role of the constructor. And one last thing, and this goes for both constructors as well, or any other contracting party with an owner. We have seen multiple scenarios where there can be overly onerous clauses that are included in a contract. Elements that it would just be almost impossible to enforce or to live up to for that particular party. Again, you just want to watch for these. Essentially, in light of Sudbury, we've seen many clients, many owners, and others swing the pendulum too far to the side of trying to dump all of your responsibilities contractually. Instead, what we want to do is find that balance and really do focus on enforcement. And of course, the last two phrases, as I can't emphasize this enough, is stay in your lane and document, document, document. So with that said, we're into the questions and answer phase here. And as I understand, Brian is going to be able to raise some of them.
Yeah. Thank you, Patrick. And before I do so, and as just to provide a little bit more context as to who you are, Patrick Groom is with McMillan LLP and is a certified specialist in labor law as designated by the Law Society of Ontario, with more than 20 years experience as a litigator, and as we've seen here today, has developed particular expertise in construction labor relations, providing practical and proactive advice about health and safety programs and defending charges under the Occupational Health and Safety Act. So with that, Patrick, as you noted, we do have some questions before us. So first question here, general housekeeping is, I think, of interest to all as to whether or not the presentation will be made available. And a link to today's presentation will be provided to all in attendance, whereby a copy of Patrick's presentation will also be included. So the first question for you, Patrick, can documentation of health and safety discussions between the owner and the constructor work against the owner? As example, could it be evidence of the owner taking control?
Of course, it's always contextual. And again, I can't emphasize enough that due diligence defense is very fact-based. However, there is that possibility. But again, what you want to document should follow your actual actions. If an owner is ensuring that it's only focused on ensuring compliance by the constructor and getting regular reports, for example, from the constructor as an update, Again, you're not taking those actions directly. Instead, you're taking them to the constructor and having that party go and enforce them. And as long as you're staying within your lane, as long as you're continuing to take actions in that limited yet very specific role, any documentation, any notes about that is going to be absolutely important, absolutely key to establishing a due diligence defense should you ever need it. So I guess this, to put it another way, could it be evidence of taking control? Perhaps, but it really shouldn't be, because the actions you're taking are focused on your interactions with the constructor directly and not other parties on the site.
Okay. Next question. Are there instances where the owner crossing a line and taking control is justified and or perhaps necessary? For example, if there's an imminent risk of injury or death.
Um, yes. And then again, I'm qualifying that yes, as a good lawyer should, I guess. But the key thing here, and I come back to that example that I mentioned earlier about the city of Sudbury having the ability to shut down the site. Again, like I had mentioned, I think the city of Sudbury was skating on thin ice and when it let the work continue without proper fencing and without proper traffic control. Um, there was some other factual circumstances. And again, it's hard to dive really too deep into those facts because the limited nature of the initial trial decision from the Ontario Court of Justice. But from what we do know, the city could have taken those steps. Certainly the Crown was arguing it should have. And but I think that said, if there's an imminent risk, if there is something completely obvious that could result in injury or death, then every party on the project would have a duty to intervene.
Okay. Next question. What is the owner's responsibility um, if they hear that a contractor's employee was injured on a job, for example, injured by a piece of construction equipment?
So the responsibility of an owner in that case would be to again engage with the constructor, not the employee and not that subcontractor directly. You're engaging with the party who's responsible for ensuring health and safety. That's part of what I want to emphasize when you're ensuring compliance. For example, what occurred, the result of that, or what the injury was, what steps have been taken to remedy that hazard. All of those things should be contained in a report or multiple reports through the health and safety procedure, or sorry, the health and safety policy that the constructor has in place for the site. So what you would be looking for as an owner would be to ensure compliance with that. Instead, you'd be going to, in this case, you'd be going to Interpaving and saying, I heard this happened. Where's the report? How have you addressed this? And you want to ensure that the constructor is then complying and enforcing its own policy.
Next question. What are the owner's responsibility for health and safety when a consultant is performing work on their behalf on a site where it isn't necessarily a project as defined under the Occupational Health and Safety Act? So, for example, design investigations, geotechnical investigations, or traffic counts, all within a municipal right of way.
So this is, again, what we're talking about here today is only within the context of a construction project. So something where a notice of project has been issued and a designated constructor is registered with the Ministry of Labor. When you're dealing with something like that, again, it's very, very fact specific, so I'm hesitant to give a solid answer, but I'll say it, generally speaking, it would be the requirement of the consultant, because again, this is not a construction project yet. So it would be the responsibility of the consultant and their employer to ensure that they're following their own internal health and safety program.
Another follow-up question. You made a comment that an owner should not review and comment on the contractor's health and safety plan. What about in the case where an owner notices errors or omissions in the contractor's health and safety plan? How would you suggest the owner handle this without appearing to take an active role in developing the contractor's health and safety plan?
Um, and that's a great question. The way I would approach this, and again, everything is very fact specific. So I guess the first thing I would say is consult with your counsel before taking any steps um, in respect of bringing that up with your contractor. But the key element there would be making inquiries. Shouldn't like, is this missing? Or, we don't understand this procedure. Can you explain it to us? You don't want to be in a position where you're actually rewriting something or you are demanding the implementation of a certain procedure. So again, that's a fine balance and it's very fact specific, but again, you don't want to be in a situation where you have a record that says, oh, we've reviewed this and there seems to be a giant gap, but we ignored it because that can come back to bite you as well. Again, it's a fine balance, but the main focus would be on ensuring that the contractor is the one fulfilling those duties.
Great. I guess last call for any more questions from attendees. Oh, we have one more. How far can a contract inspector on site go when trying to call out public safety versus worker safety, and how these actions impact systemic departmental bureaucracies of the owner?
Bear with me. I'm just reading. I was just able to pull it up. I'm just rereading it here. No, okay, that's a great, the fact that you're mentioning about that competing interest is a great question. Again, like I said, this is all very fact-based analysis, so you would have to consult with counsel given that particular scenario. I think in broad strokes, though, whether it's no matter what who the party is, if they are if they have a justified and serious health and safety concern, you still have a duty under the Occupational Health and Safety Act to take all reasonable steps. And so if I mean, potentially, I'm just again drawing on one example to try and illustrate a possibility. It might be that you've documented that the issue has been raised. Here's been the response. We weren't satisfied with it, so we actually went back and got additional information. We requested additional steps be taken. And then with respect to our own specific issues, it's been addressed to our satisfaction. And if it hasn't been addressed to our satisfaction, then you really do have to look at, okay, so we might have agree to disagree, or we might have a competing interest, but what are my actual obligations? And that's really the question that we would have to focus on in that scenario.
We've got another question here. If the understanding is correct, is it current legal perspective or view that the owner is always considered an employer and must therefore always consider the position of due diligence?
That's unfortunately the key takeaway out of the Court of Appeal decision, the Ontario Court of Appeal decision, is that you have to be prepared. I mean, the law may evolve, decisions may change in light of, again, the most recent element of due diligence and that importing control into the analysis. But in short, the Ontario Occupational Health and Safety Act does say if you retain a worker or if you retain a contractor, then you become an employer. And in fact, that's what the Court of Appeal had held, and that's what half of the 4 of the 8 justices in the Supreme Court of Canada had agreed with. In fact, in the decision of those 4 that agreed with the Court of Appeal, they even raised some other speculative situations that would even expand that further. Luckily, that decision is not applicable. Could be persuasive. It could offer some guidance should a court, face a situation where the definition of employer is really fuzzy, or whether or not they are an employer. But as a general principle right now, I would advise an owner to make sure that they take these steps necessary to ensure that, again, that they are enforcing and ensuring compliance with or ensuring, I should say, sorry, the constructor is complying with its own policy.
One more question. If the owner retains a consultant, does the owner become an employer, either on a construction project site or otherwise?
So again, this is all within the definition of a construction project. So I'm going to park the otherwise, because that would lead to a pretty different analysis. But again, if you're retaining, it's a worker. That's what it is. And worker is broadly defined as pretty much anybody who performs work on the site. And so if you have a consultant and they're performing work on the site, much the same way that the employees of the city of Sudbury were ensuring quality control and monitoring project process, or project, sorry, continuation, progress, that's the word I was looking for. If they're there ensuring project progress and monitoring that, that is still work on a construction site. That was one of the two key reasons that the city of Sudbury was considered to be an employer. So I think the short answer is potentially yes.
Another question. Is the municipality absolved of incident responsibility should the contractor fail to abide to a direction to a job stoppage and an injury was subsequently to occur?
Now that's a very unique situation. I don't think I can remember a situation where somebody said, I'm going to continue working anyway, even though you told me not to. But I wouldn't say absolved. Again, this is all about taking steps to ensure you can prove you've done your due diligence, that you can show you've taken all reasonable steps within the context of your role to ensure health and safety on the site.
Last call for any questions from attendees. It appears as though, Patrick, you've answered everyone's questions, and you've certainly provided a wonderful perspective in terms of that matter. And we thank you and everyone in attendance for your time, and stay tuned for details with respect to provision of today's presentation in the near future.
Well, thank you very much for having me, everyone. Have a great afternoon.
Bye now.
Bye-bye.